Stop scrolling. If you have just walked out of your solicitor's office with a 3-inch binder labeled Living Trust, you are likely feeling a profound sense of accomplishment. You have spent weeks, maybe months, thinking about your legacy and making the difficult decisions required to protect your family's future. You have started the process of transferring your life savings, your home, and your bank accounts into that legal wrapper, feeling that everything is finally secure. But then you look at your pension statement, your health savings account, or even your car title and think, should I put these in there too? Stop right there. Because if you move the wrong assets into your trust, you won't just create extra paperwork, you could accidentally trigger a 6-figure tax bill, destroy your liability protections, or create a legal nightmare for your children that takes years to unwind. Today, we are covering the 5 assets you should never, under any circumstances, put into your revocable living trust. I am talking about the mistakes that even very smart people make simply because nobody warned them about the hidden traps in the tax code. I am the Wealth Guardian, and the mission of this channel is to protect your wealth through education. I am here to help you secure your legacy without the exhausting legal jargon, and this information might just save your family thousands of dollars and countless headaches. If you are new here, we break down estate planning, tax strategy, and wealth protection so you can make confident decisions for your family's future. Please like, subscribe, and hit the notifications bell, because with significant tax exemptions scheduled to change by 2026, the strategies we discuss here are about to become critical for millions of families. Before we dive into the strategy, I must be clear, I am not an attorney, and I am not providing personal legal advice, nor am I a financial advisor. Every state has slightly different rules, so please take this information as education and then go speak with a qualified elder law attorney in your area. Now, funding your trust, which is just a fancy way of saying transferring ownership of your assets into the trust's name, is usually the whole point of the exercise. That is how you avoid the probate process, which can be a slow, public, and expensive ordeal for your heirs. However, these 5 assets are the exceptions that prove the rule. They have special tax treatments, unique legal structures, or hidden liability traps that make trust ownership a very costly mistake. Let's dive into the first one, which is the most common error I see. Number 1. Tax-qualified retirement accounts. This means your traditional IRAs, Roth IRAs, 401ks, 403bs, and similar pension plans. Basically, anything with those magical tax-deferred or tax-free growth benefits. Here is the critical distinction you must understand. These accounts are designed by law to be owned by an individual, you, not a legal entity like a trust. Moving these into a trust can trigger immediate taxes. If you actually retitle the account into your trust's name, the IRS considers that a full distribution of the entire balance. We are talking about the total value of your retirement nest egg becoming taxable income to you in a single calendar year. If you are under 59 and a half, you can add a 10% early withdrawal penalty on top of that. You could potentially turn a $500,000 retirement account into a $200,000 after-tax disaster simply because you checked the wrong box on a form. Furthermore, naming a trust as the beneficiary rather than the owner can still be risky. Unless that trust has very specific see-through provisions, you might force your heirs to withdraw the entire balance within 5 years, destroying the ability to stretch those tax benefits over their lifetimes. For most people, the cleanest solution is naming your spouse as the primary beneficiary and your children as contingent beneficiaries directly on the account's designation form. It bypasses probate, maintains the tax advantages, and keeps your life simple. Number 2, health savings accounts, or HSAs. HSAs are triple tax advantaged wonders. You get a deduction going in, tax-free growth, and tax-free distributions for medical expenses. But here is the catch that trips people up. Legally, only an individual can own an HSA. Not a trust, not an LLC, and not a corporation. If you attempt to transfer your HSA into your living trust, the account immediately ceases to be an HSA in the eyes of the law. The entire fair market value becomes taxable income in that year. Plus, if you are under 65, non-medical withdrawals trigger a 20% penalty. You just turned your healthcare safety net into a massive tax bomb. Instead, keep the HSA in your name and name a beneficiary directly on the account. If your spouse inherits it, it becomes their HSA, tax-free. If it is someone else, they will pay tax on the value, but they can use it to settle your final medical expenses. Keep it out of the trust entirely. Beneficiary designation beats trust ownership every single time for these accounts. Number 3, your vehicles, cars, trucks, boats, and yes, even that motorhome you use for summer holidays. I know your solicitor might have mentioned putting vehicles in the trust to avoid probate. But in most jurisdictions, transferring titled vehicles into your living trust creates three massive problems. First, and most importantly, is liability exposure. If your trust owns the vehicle and you are involved in a serious accident, a plaintiff's attorney could argue that all assets held in that same trust, your house, your savings, your investment accounts, are now exposed to the lawsuit. By putting the car in the trust, you might be handing a creditor a key to your entire vault. That is the opposite of asset protection. Second, many insurance companies charge significantly higher rates when a trust owns a vehicle, or they require complex additional insured endorsements that are a headache to maintain. Third, it is usually completely unnecessary. Most areas have streamlined probate procedures specifically for vehicles, or they allow for transfer on death registrations. You can name a beneficiary right on the title or registration. When you pass, they simply take the death certificate to the motor office, and the vehicle is theirs. No probate, no trust administration, and no insurance nightmares. Number 4, life insurance policies. This one often surprises people because we hear about specialized tools like irrevocable life insurance trusts as sophisticated estate planning devices. But if you have a standard revocable living trust, the kind that the vast majority of people use, do not transfer ownership of your life insurance into it. Here is why that matters. If your revocable trust owns the policy, the death benefit is typically included in your taxable estate. With the tax exemptions scheduled to drop significantly after 2025, you could be looking at a 40% tax on money that should have gone to your children tax-free. Instead, name human beneficiaries directly on the policy. They get the money within weeks, tax-free, without any probate delays. If you have minor children and are worried about them receiving a large lump sum, that is when you name the trust as the beneficiary, but you should still never name it as the owner during your lifetime. Number 5, foreign real estate. Whether it is a holiday condo in Spain, a cottage in Ireland, or a villa in Portugal, putting foreign property into an American or UK-based trust usually doesn't work the way you think it will. Most countries, especially those with civil law jurisdictions, do not recognize foreign trusts in the same way we do. When you pass away, that country will likely apply its own forced heirship laws, potentially overriding your trust entirely and requiring a local probate process anyway. Worse, some jurisdictions view the act of transferring property into a trust as a taxable sale, triggering immediate capital gains taxes or transfer taxes. You end up paying taxes now and dealing with foreign probate later. The better approach is usually to own foreign real estate through a local entity or simply to have a separate will drafted in that specific country that complies with local law. Don't clutter your domestic trust with foreign assets, they speak different legal languages, and your trust document often won't translate. The theme across all 5 of these assets is simple: just because you can retitle an asset doesn't mean you should. Your living trust is a powerful tool. It is essential for your home, your taxable investments, and your personal property. However, to truly protect your legacy, you must avoid the traps that destroy most family wealth: waiting until a crisis to plan, giving away cash directly without structure, or failing to understand the tax implications of ownership. Always ask yourself 3 questions before moving an asset. What happens to the tax treatment? What happens to my liability protection? And is there a simpler way to transfer this at death, such as a beneficiary designation? Your wealth guardian shield is built on foresight. Long-term financial security is a reality for those who plan, but how you structure your assets is a choice. I want to hear from you. Have you already started organizing your estate, or are you just beginning to realize exactly how much is at stake? Let's get a real conversation started in the comments section so we can all learn from one another's experiences. I want everyone watching to type the word assets in the comments below if you are committed to securing your financial legacy this year. While you are there, tell me which of these 5 strategies surprised you the most. Was it the retirement account tax bomb, the specific issues with vehicle titles, or the fact that your life insurance ownership could trigger a massive tax bill? If you find this valuable and want to secure your family's future, please like, subscribe and ring the notification bell for instant updates. Your support allows me to help other families protect their assets before it's too late. Don't leave your legacy to chance, stay prepared, and I'll see you next time.